Step 5. Publication. Publication of notice. Under the provision of Section 23 of Presidential Decree Number 1529, the Administrator of Land Registration Authority, upon receipt of the order of the court setting the date for initial hearing, shall cause a notice of the hearing to be published in the Official Gazette and once in a newspaper of general circulation in the Philippines. The notice is to be addressed to all persons appearing to have an interest in the land involved, including adjoining owners so far as known, and in general to whom it may concern. The notice requires all persons concerned to appear in court on the date and time indicated to show cause why the application for registration should not be granted. Publication in the Official Gazette. It shall be sufficient to confer jurisdiction upon the court. The publication in the Official Gazette binds the whole world, inclusive of those who may be adversely affected and those who factually have been innocent of such publication. This is the only way to give meaning and finality and indefeasibility of the Torrens title to be issued.
Publication of notice of initial hearing in the newspaper of general circulation is a mandatory requirement.
Purpose and effects of publication. First, to confer jurisdiction over the land applied for upon the court, and second, to charge the whole world with knowledge of the application of the land involved and invite them to take part in the case and assert and prove their rights over the property subject thereof.
Form of notice. The aforementioned Section 23 requires that copy of the notice of initial hearing duly attested by the Administrator of Land Registration Authority be posted by the Sheriff of the province or city in a conspicuous place on each parcel of land as well as on the bulletin board of the municipality or city in which the land is situated at least 14 days in advance of the date set for the hearing. The notice shall be substantially in the form prescribed in said Section 23. The said section also never meant to dispense with the requirement of notice by mailing and by posting. The date of mailing of the motions, pleading, or any other papers which may include instruments as the deed of the nation is considered the date of filing as shown by the post office stamp on the envelope or registry receipt. Mailing and proof of publication and notice. The time fixed by law for the initial hearing of the case is not less than 45 days nor more than 90 days from the date of the order, and within 7 days after the publication of the notice in the Official Gazette, the Administrator of Land Registration Authority shall cause a copy of the notice to be mailed to every person named therein whose address is known. If the applicant seeks to have the line of a public way determined, the administrator shall cause a copy of said notice to be mailed to the city or municipal mayor and the provincial governor concerned. If the land borders on a river, navigable stream, or shore, or an arm of the sea where a river or harbor line has been established, or on a lake, or if it otherwise appears from the application or the proceedings that a tenant farmer or the national government may have a claim adverse to that of the applicant, notice shall be given in the same manner to the Department of Agrarian Reform, the Solicitor General, the Director of Lands, the Director of Mines, and or Director of Fisheries and Aquatic Resources. Other persons may also be furnished the same notice if the court may deem it proper. The court, whenever deemed possible, shall require proof of actual notice to all adjoining owners and to all persons who appear to have interest in or claims to the land involved. Mailing of notices to such persons shall be registered by mail, if practicable. The certification of the administrator and of the sheriff concerned to the effect that the notice of initial hearing, as required by law, has been complied with and shall be filed in the case before the date of initial hearing, and shall be conclusive proof of such facts. It may be stated that, in this connection, the strong considerations of policy require that this legal presumption of conclusiveness be allowed to operate with full force. A party to an action has no control over the administrator or the clerk of court acting as a land court. He has no right to meddle unduly with the business of such official in the performance of his duty.
In the case of Director of Lands versus Court of Appeals, GR number 102858, July 28, 1997. The facts of the case. Private respondent Teodoro Abestado filed a petition for original registration of his title. However, during the pendency of his petition, applicant died. Hence, his heirs, represented by their aunt Josefa Abestado as guardian ad litem. The Land Registration Court dismissed the petition because the applicants failed to comply the provisions of Section 23, Number 1 of PD 1529 to publish the notice of initial hearing in a newspaper of general circulation in the Philippines. It was only published in the official gazette. The trial court affirmed the decision of the Land Registration Court. Unsatisfied, the private respondent appealed, which the Court of Appeals set aside the decision of the trial court and ordered the registration of the title in the name of Teodoro Abestado. Since CA denied the subsequent motion for reconsideration, the petitioner, represented by the Solicitor General, elevated the recourse to the Supreme Court. Now, the issue of the case. Whether or not the publication of the initial hearing in the official gazette shall suffice the requirement, and any of its publication in a newspaper of general circulation is not indispensable in the application for registration of title. So, ruling of the court. No, the publication of the notice of hearing in the official gazette shall not suffice the requirement, and any of its publication in a newspaper of general circulation is indispensable in the application for registration of title, because the court ruled that Section 23 of PD 1529 requires notice of the initial hearing by means of publication, mailing, and posting, all of which must be complied with. If the intention of the law were otherwise, said section would not have stressed in detail the requirements of mailing of notices to all persons named in the petition. Indeed, if mailing of notices is essential, then by parity of reasoning, publication in a newspaper of general circulation is likewise imperative, since the law included such requirement in its detailed provision. Moreover, publication in a newspaper of general circulation should be deemed mandatory, though in this case, publication in the official gazette as well as by mailing and posting were already complied with, for the reason of due process and the reality that the official gazette is not as widely read and circulated as newspapers and is oftentimes delayed in its circulation, such that the notices published therein may not reach the interested parties on time. In all-encompassing in rem, nature of land registration cases, the consequences of default orders issued against the whole world, and the objective of disseminating the notice in as wide a manner as possible demand a mandatory construction of the requirements for publication, mailing, and posting. Therefore, the application of private respondent for land registration was not granted.